welcome to the 30 Years, 30 Cases of the Court of Justice of the European Union, a series of podcasts launched by ERA, Academy of European Law, marking its 30th anniversary. My name is Luisa Curtá. I am course director at the environmental law field at ERA, and today we are discussing a judgment from 2008, the case number C-23707, so-called the Janecek case. In a nutshell, this ruling concerns the interpretation of Article 7.3 of Council Directive 9662 EC on ambient air quality assessment and management. Mr. Janecek had asked for an order requiring the Freistaat Bayern to draw up an air quality action plan in the Landshütte Halle district on Munich's Central Ring Road, where he lives. In that way, he hoped to achieve that in the future, PM10 emission limit values would no longer be exceeded more than 35 days a year, as stipulated by EU law and transposed nationally. 3 questions were then brought to the European Court. First question, whether an individual has the right to bring an action to require the competent national authorities to draw up an air quality action plan where there is a risk that the limit values may be exceeded. Second and third questions, whether the competent national authorities are obliged to lay down measures which, in the short term, would ensure that the limit value is attained, or whether they can confine themselves to taking measures to ensure reductions in instances of the limit value being exceeded or limits on their duration, and which are, consequently, liable to make it possible for the situation to be improved gradually. So there were, of course, different factual and legal issues discussed in this case, all very relevant to the understanding of the extension not only of air quality protection, but also of access to justice for citizens. And to navigate us through those, the expert guest today is Hugo Tadei, who is the head of the Clean Air Program within Client Earth. Client Earth is a public interest environmental law NGO that uses the power of law to protect our planet. It focuses on a range of environmental topics from climate change to protection of nature and environmental rule of law. Hugo's work aims to enforce compliance with EU air quality laws through litigation before national courts in EU member states. He is involved in litigation in more than 13 European states, including the series of successful clean air cases in the UK and the legal actions in Germany resulting in court orders to restrict access of diesel vehicles in cities. Hugo joined Client Earth in 2014 and is based in the Brussels office. He is a qualified lawyer in Italy and holds a degree in law from the University of Florence in Italy and a degree in environmental law and policy from the University College London. Hugo, welcome. And thank you very much for accepting our invitation and being with us today. Could you please start by explaining to us the factual background and the legal questions in the Janecek case?
Thank you, Luisa, and thanks for inviting me to speak today. It's a pleasure to be with you. And yeah, it's a pleasure to talk about this case because it's really a fundamental precedent in European environmental law. And it deals with a very fundamental issue. Every people has a fundamental need to breathe clean air. And in this fact, unfortunately, air pollution in Munich was too high and harmful for people and did not comply with the relevant European laws. In order to reduce pollution, the European Union had introduced some binding provisions. And these at the time were included in the Directive 9662 on ambient air quality. They basically, together with a follow-up daughter directive adopted in 1999, introduced so-called limit values. These are maximum concentration of pollutants and require member states to reduce them below certain concentrations. In this particular case, the matter related to PM10, which is an acronym that refers to particulate matter. These are tiny particles, often generated by combustion in vehicles, domestic heating, industrial processes. And these particles are very harmful because when we breathe them, they enter in our lungs and in our system, having impacts on stroke and cardiovascular diseases and lung problems. European laws required to reduce concentration by 2005. However, in Munich, in Landschutte-Allee, the road where Mr. Janecek lived, in 2005 and 2006, there have been exceedances of these legal limits. The authorities had adopted a general plan to reduce pollution in the area as required by Article 8 of the directive, but they did not have put in place another type of plan, so-called short-term action plans that were required by Article 7 of the directive. And these are plans that require the authority to take steps to reduce the risk of exceedance of very high concentration in the short term, so daily concentration reaching harmful level. In the situation was that there was a clear breach of the law. There was a failure of the authorities to have all the policies and the plans required by European law in place. But Mr. Janecek wondered, can I take the authorities to court and force them to comply? And this may seem a very simple question, but it wasn't that obvious at the time. And one key problem is that there was no clarity on whether individuals and NGOs had access to courts to hold governments accountable and force them to take action. In the directive, there was no explicit access to justice provision, and the rules around access to justice, which are included in international treaties like the Aarhus Convention, had not been implemented in Europe. So there was no general rules around access to justice introducing binding legislation in Europe at the time. So Mr. Janecek decided to try, nevertheless, to go to court. And this sparked a very interesting debate and legal battle with in the end reached the European Court of Justice.
Thank you so much for this very clear explanation of the general aspects of the case. So if we understand correctly, a first important point that was in question was the possibility for legal standing of individuals to request the adoption of changes to an air quality plan. So what was the legal discussions and analysis to this regard?
Yeah, that was a crucial debate. I mean, in other fields of law, when let's take private law, if there is a breach of a contractual obligation, no one will ever doubt that the people entitled to the service of the good has a right to go to court and demand judicial protection. Here, however, we are in the field of environmental law, so there are some obligations that are supposed to protect the general population or the general environment. So there was a question on whether the obligations that European law introduced for member states around limit values, so to reduce levels of pollution, and the adoption of action plans, which are administrative management plans to improve air quality. The question was, do these EU obligations also confer a mirror right to people so that people can go to court and demand protection if governments are not complying with their obligations? And the courts in Germany had taken different approaches. So the first court dismissed the case. The Court of Appeal actually granted the remedy to Mr. Janecek, and then the federal court took a very interesting approach. The federal court, if we read it, their opinion was that there was no personal right of the individuals, but they acknowledged that there was a dispute, that it wasn't clear how to interpret European law, so they did the right thing. they put the case on hold and they refer the matter to the Court of Justice of the European Union, who plays this crucial role of interpreting European Union law and clarifying how it applies. And it is very interesting also to read the arguments of the parties. Mr. Janecek argued that individual citizens and people do have a right and they should be able to take legal action against authorities to make sure that they comply with the limit values and that they put in place the plans required by the directive. In doing this, Mr. Janecek and his lawyer, they were relying on a previous line of cases before the Court of Justice of the European Union. These are a number of infringement cases. There were 3 sibling judgments in a very short span at the end of the 1980s in cases Commission versus Germany, C-361/88, C-59/89, and C-58/89. In all these 3 cases, the European Commission took Germany to the Court of Justice, asking them to introduce binding legislation for air quality standards or water quality standards. And the rulings for the Court of Justice in these cases are fundamental because they said that these provisions on environmental quality standards and air quality standards are aimed at protecting human health of people. So member states are obliged to put these rules in legislation to make sure that people can protect their rights in this field. So there was something already in the air in this ruling because there was a mention of rights, but this ruling had remained quite dormant, let's say, for a long time until Janecek tried this action. On the other hand, the member states were trying to say air quality laws, they provide obligation for member states, but these are general public obligations for the public interest and do not confer any right to people. So there shouldn't be access to justice for people, even if there are breaches. As you can understand, if that would be the case, there would be big rule of law problem because member states could basically simply ignore legislation. There would not be any consequence for them. The answer from the Court of Justice on this dispute is crucial and one of the most important rulings on access to justice in environmental matters. The Court of Justice answered very clear affirmative, saying that natural and legal persons affected by the risk of exceedance of limit values should have standing to require adoption of a plan. So they should be able to take governments to court to make sure that they comply with these obligations. And this was a very important decision.
The possibility of legal standing was then confirmed. So another aspect under analysis by the court on the Janecek case was then to which extent a judicial review of the content of air quality plans can be made. What were the discussions there and the conclusions that they draw?
Well, I mean, as you can guess, it is important to be able to go to court and demand the adoption of a plan, but that's often not enough. If the plan is not good, then you're back to square zero. So it is essential to be able to pass to the court also to review whether the plan has the right measures, has the right content to deliver on the obligation to improve air quality and protect health of people. And not surprisingly, here again, we see the two parties having widely different approaches. Mr. Janecek was trying to argue that the directive require member states to put in place short-term action plans that will achieve compliance in the short term with the limit value. So that they put quite strong constraints on the discretion of authorities on the adoption of the policies. On the other hand, not surprisingly, member states were trying to protect their field and say we have a lot of discretion. Courts should not be able to review what we adopt. Air quality plans should be able to balance a lot of different interests, not only human health, but also economic interests and social consideration and so on and so forth. Here, the answer from the Court of Justice took, let's say, a sort of middle ground, and it's based on the very wording of Article 7 of the Directive 96/62 at the time. Article 7 required the adoption of short-term action plans to reduce the risk of exceedance. So it was to reduce the risk of exceedance, not to eliminate completely any exceedance, or to limit the duration of exceedances. So again, not to put immediately an end on the exceedances, but to make basically reduce how long these exceedances will last. So based on this wording, the Court of Justice basically came to the conclusion that this type of wording left quite a bit of discretion to authority to balance competing interests. So not only the goal of achieving compliance with the limit values, but also the opportunity to consider socioeconomic interests or the cost of the measures. And so that basically what the directive required was for authorities to gradually improve air quality, taking into consideration all competing interests. But even if the Court of Justice acknowledged that there is discretion and power of authorities to balance different interests, they said that nevertheless, this doesn't mean that there should not be any judicial control. So that there should be a possibility for judges to review the content of the plans and see whether they remained within the limits of discretion of the directive. So here we see a more mixed answer from the Court of Justice, but this final part, I'm saying that even if there is discretion, there are limits and there should be judicial review, was a very important seed because just shortly after the Janecek case that was decided in 2009, at the same time, European Union was changing air quality laws. So the directive that was the basis for this case, it was from 96, but a new air quality directive was adopted in 2008, Directive 2008-50 EC. They introduced much stronger wording around air quality plans, requiring in Article 23 to achieve compliance in the shortest time possible. And this, based on the seed in Janecek, then brought like a very important opportunities in the next stage.
We can now see very clearly why this is considered a landmark judgment. But what were then the implications of it, for instance, in later air quality litigation?
Yeah, Janecek is indeed a fundamental precedent. I mean, the principle that individuals have a right to take governments to court and force them to comply with air quality laws was a landmark decision. And the importance here is that the rulings of the Court of Justice of the European Union are binding all across Europe. So it was not only important for Mr. Janecek in his battle for clean air in Munich, but it was a fundamental ruling for all European citizens. Following this action, it was a very solid precedent on access to justice that allowed the thousands, hundreds of thousands of citizens living all across Europe that are still exposed to very high levels. Sorry, can we start again? Yeah, I got mixed up with the numbers. We have clearly more than hundreds of thousands of citizens in Europe, maybe more than that. I'll start again from the beginning. Yeah, Janecek was indeed a fundamental precedent. The ruling that citizens and NGOs do have standing to fight for the right to clean air and take the governments to court was a very important ruling for access to justice in environmental matters and specifically for air quality. But it was important not only for Mr. Janecek in his battle, but for all European citizens across Europe, because rulings of the Court of Justice of the European Union are binding. So once a ruling of the court is issued, this is binding as European law, and it provided a very solid ground for citizens and NGOs to fight for clean air all across Europe. The decision in the Janecek case in particular opened the way to a very rich body of litigation, both at national level, but also a number of other very important rulings before the Court of Justice of the European Union. For instance, I've already mentioned that at the same time of the ruling, the European Union had introduced new and stronger air quality laws in the Ambient Air Quality Directive from 2008. And my organization, Client Third, used these new provisions in the UK to take the UK government to court around breaches of air quality laws. And that case, again, ended up referred to the Court of Justice of the European Union. That's case C-404/13, Client Third. And that case built upon Janecek. It confirmed that there is standing, but it took a much stronger decision regarding the content and the review of the content of plans. Based on the stronger wording of the directive, the Court of Justice clarified that there is an obligation of result of authorities, and the judicial review needs to check if the policies adopted will achieve compliance in the shortest time possible. And this really opened up a very rich discussion on basically a very solid case law now from the Court of Justice, saying that when deciding the policies, authorities cannot rely on socioeconomic complexity or technical complexity or financial complexities to delay introduction of policies that would improve air quality and would protect the health of people. Similarly, there was a case in Brussels, the Crines case, C-723/17, that was about standing on a different part of the directive. So whether there is standing to challenge authority on how they measure air quality, where they put monitoring stations. And that's essential, because if you don't measure air pollution properly, you don't know what are the problems, and you don't know what policies to adopt. And again, the Court of Justice confirmed that there is standing. And again, it confirmed that these rules are meant to protect fundamental interests. So the review, of course, needs to be very thorough, a full review of the discretional authorities, even if the matters are technically complex. And I mean, I could go on for hours, but just closing on the follow-ups on Janecek. Currently, there is a case pending before the Court of Justice, case C-6121, Ministre de la Transition écologique. This is a case from France where a citizen is taking the French government to court, claiming for compensation for the health damage suffered because of the breach of the air quality limit values. And this, again, you can see it's drawing back a circle, because the issue now is whether this citizen has a right to clean air and a right to compensation. We've seen that all the debate on Janecek was whether there is a right to clean air. There's been an opinion from Advocate General Cocotte just at the beginning of May this year, suggesting, in her opinion, that there should be a right to compensation, and drawing a very strong line between fundamental right and protection of human health in air quality matters. We'll see if the Court of Justice will support this type of ruling, on this type of reasoning in the ruling.
Thank you so much for clarifying the details of the Janecek case and its main implications. And would you now be able to draw some conclusions and apply them to current state of discussions?
Yeah, I think, I mean, the Janecek case, I think that can give a very good lesson to learn about environmental law more generally. It shows that having environmental laws adopted is fundamental, but is not the end of the game. Having laws adopted on paper, if they're not followed by implementation and enforcement, is not enough. And there needs to be judicial check to make sure that governments deliver on the environmental objectives that they set for them and for the protection of people. And if we look at the field of air quality, unfortunately, we're now 15 years after the introduction of limit values, but we still have widespread exceedances of limit values in the majority of the European member states. And these violations have huge impacts on the health. The European Environment Agency estimates that an estimated 300,000 premature deaths happen every year because of exposure to air pollution. So it is a very fundamental problem. And we need to have enforcement from citizens and NGOs. Following the Janecek case, we've seen that a lot of citizens and NGOs have been keen to actually take action and go to court, put pressure on the government and try to improve what is done to tackle air pollution. Klein Chart as an NGO, we have been helping and working together with individuals and NGOs in more than 13 countries and bringing more than 80 litigation cases before national court. And we have seen that litigation works. Just to mention an example, some actions, we've taken legal actions in Germany that have been pushing for the introduction of restrictions on diesel vehicles, which are harmful and polluting in cities. And we have seen that the cities where we've taken litigation have been improving air quality twice as much compared to the cities where there has not been litigation in Germany. So we see that the pressure actually help pushing authorities to take the right step, go in the right direction, and protect this fundamental right that everyone has to breathe clean and healthy air. Indeed, and many thanks. And I think that with those remarks, we may close our discussions regarding the case C-23707, Dieter Janecek against Freistaat Bayern, or the Janecek case. And this is the end of the podcast today. Thank you very much, Hugo, for the very clear and interesting inputs and reflections. It was a true pleasure talking to you today. Thank you very much, Luisa.